Look at them people, attorneys behind him. They're like, what is going on with this guy? What is he rambling about? He can't even find his paperwork. Look at that. 8 lawyers working for the government.
I apologize, Judge. I didn't bring the court a copy of that Henry Gwinnett County grand jury case, but that's the case that counsel relied upon and cited in its.
Folks, you got to get this. I just want to make sure you understand this, okay? This is Attorney Nathan Wade, the government's attorney, who's been paid up to $724,000, up to $1 million for this case. As of right now, he's before the judge, stuttering his words, not able to put his thoughts together evenly. He's pausing, long pauses between words. He's reading what looks to me like from a law book, just basically random bullet points pertaining to grand juries when it should be about special grand juries. He turns to the other attorneys. There's supposed to be a total of 8 of them working for the government, and he can't find his paperwork. I apologize, Judge. I can't find my paperwork. Are you kidding me? What in the world is going on? This should have been what's called a clue. All right, welcome back to all my free-minded friends. J.R. Dukes at your service once again. We are in the middle of a series looking into proof of Nathan Wade's incompetence and handling really any type of trial case, but specifically felonious cases. And of course, with our former president, Donald Trump, he is definitely not qualified for RICO cases. And I have the absolute proof. We have been looking the last few days. This is number 3 in the series of Nathan Wade in court. This is him in the first or second court hearing pertaining to this RICO matter. We are in the courtroom. Nathan Wade is addressing the judge. His incompetence is just palatable. It's everywhere. It's very easy to recognize. They are supposed to be discussing 3 different motions, and Mr. Wade is not able to understand the difference in a special purpose grand jury, what they call a special grand jury, or a regular grand jury. And the judge is using extremely soft measures, kid gloves, if you will, trying to say, hey, let me help you out. So without further ado, let's get right back into it and let's talk about this, because this is extremely interesting. It's just more proof of the fraud put on by Fani Willis and company in the Fulton County DA's office. Here we go.
A regular grand jury obviously passes down the indictment. So
I think Mr. Aurora's argument is that there's a particular statute that only applies to special grand juries that might impact that.
There's not.
Okay.
What is that statute?
Well, he cited 1512-8, I think it was. 1580, excuse me. And why not?
Well, for practical purposes, Judge, it's the same function with the exception of the charging element. The special purpose grand jury is an investigative tool, investigative jury.
Folks, just a quick side note, even I know, and I'm sure you know, that if a special grand jury and a grand jury were exactly the same things, why would they call it 2 different things? I mean, isn't that kind of common sense? And as I showed you yesterday, a quick Google search, typing in what is a special grand jury and the difference of a grand jury in the state of Georgia, clearly showed without any hesitation that essentially a special grand jury is just that. It's a special jury put together for the purpose of generally focusing on one issue, an issue like a very popular, or I should say a very famous RICO case involving a former president. That's a definite good example. Also, the duration is generally a much longer period. And most importantly, at the end of a special grand jury, they generally put out a report publicly of what their findings were. But obviously, Mr. Nathan Wade, Attorney Nathan Wade, does not know this.
Does not make charging decisions, but can make recommendations. A regular grand jury obviously passes down the indictment. So
I think Mr. Aurora's argument is that there's a particular statute that only applies to special grand juries that might impact that.
There's not.
Okay.
What is that statute?
Well, he cited 1512-8, I think it was. 1580, excuse me.
And so just so we're not confusing things, these cases talk about regular grand juries and their deliberations.
Well, I think that's the question I just put to him. So let's see where we go.
So there's a difference.
1512-83, Judge?
I think it was just 80.
That's a disclosure statute.
Did you catch that? That's not even the correct statute they're supposed to be looking at. He doesn't even know his statutes.
There is no distinction, Judge. The case law is the same. I think that particularly the Olson case that defense counsel is relying upon is not even a case that considered turning over information. That Olson case essentially it merely considered which employees a district attorney can be of a district attorney's office that can be present.
I agree with you there. I think Olson goes more towards what we're going to get to about whether they can speak to grand jurors and what about. I think, and we can, if you need to do a supplemental brief, we can do that. But the issue is, because we don't see them as often, whether special purpose grand juries have some different degree of secrecy than a regular grand jury, such that we can't just reflexively look at this case law and say, all right, not a hard call.
So, Judge, I think that the application is the same. The analysis is the same. Why is there a distinction between the special purpose grand jury versus the regular grand jury? The law is clear on the defense counsel not being able to get the transcripts or anything that demonstrates that comes out of the a grand jury process, the special purpose grand jury or the regular grand jury process, Judge. And that's the Stinsky case, the Ruffy's case, and the Isaacs case. But I like to direct the court's attention to the fact that there's no authority that demonstrates any defendant is entitled to these grand jury transcripts. Courts disfavor the release of these transcripts. Defense has pointed to no overriding factor that would override the policy favoring the secrecy of grand juries, and that is the guiding principle, Judge. It's the secrecy of the grand jury. The Supreme Court says that the grand jury is a public institution serving the community that might suffer if those
Folks, I just want you to keep in mind, so I don't lose you. I don't want you to get too bored out here, because you have to pay attention to the details, because this is evidence, hard evidence that this guy is incompetent. He is talking about a grand jury. We are looking for a special grand jury. That's what effectively began to handle this Trump RICO case. It was put together as a special grand jury. He keeps talking about grand juries. They're two different animals. It's like comparing literally apples and oranges. So let's get back into it.
Testifying today knew that the secrecy of their testimony would be lifted tomorrow. This indispensable secrecy of grand jury proceedings must not be broken except where there is a compelling necessity. They have to show what that compelling necessity is, Judge. And the Kessler case, along with the other cases the state has just given, support that proposition, but also the Supreme Court in the Anderson case does as well. Now let's talk about the Supreme Court, because they've identified five factors, Judge, that are present in the Douglas Oil case that we'd like to address.
Folks, it's so clear that he does not know what he's talking about. Look at the expression on the faces of the attorneys behind him, which are the defense attorneys for two of the defendants. They are like, where is this guy going? And why is he talking about regular grand juries versus special grand juries? Now, remember, since this hearing took place, I went back and looked and found these videos. But since this hearing took place, all of these allegations against Fani Willis and Nathan Wade, and a lot of them are no longer allegations, about their assorted affair, about the scheme to defraud the taxpayers and enrich themselves. Remember, this is the guy that, according to public reports, as of today, the best guesstimate I have is approximately $724,000 paid to this man for the performance you're seeing today. So keep that in mind as you're watching. Look at the defense attorneys in the back. Look at the judge trying to be calm and trying to compose himself. None of these people at the time knew that this guy was incompetent as far as never handling felonious cases or RICO cases. They thought he was supposed to be some kind of outside expert. So they're basically sitting around like, what is going on? Am I in the legal twilight zone?
First, if the pre-indictment proceedings were made public, many prospective witnesses would be hesitant to come forward and voluntarily, knowingly, and those against whom they testify would be aware of their testimony. That's the first thing. The second factor against releasing the information is witnesses who appeared before the grand jury would be less likely to testify fully and frankly, as they would be open to retribution and also to inducements, which we've seen a little bit of in this case. Third, there also would be the risk that those about to be indicted would flee, or fourth, would try to influence individual grand jurors to vote against indictment. 5, and finally, by preserving the secrecy of the proceedings, we assume the persons who are accused but exonerated by the grand jury will not be held up to public ridicule. Those are factors, Judge, that the court should consider in determining whether or not grand jury secrecy provision has been overridden by counsel's argument. Don't believe, Judge, that the defense has relied on any case that would override those factors, but moreover,
See, he can't get his thoughts
any
together.
treatise
It's taking him forever.
that would assist upon them in their reliance, Judge.
Unbelievable. Unbelievable.
They did cite to the Henry Gwinnett County case, Judge. And even in that case, the requirement that secrecy be maintained among all types of grand juries without distinction. And that's in the Henry. And I'll
Look at them people, attorneys behind him. They're like, what is going on with this guy? What is he rambling about? He can't even find his paperwork. Look at that. 8 lawyers working for the government.
I apologize, Judge. I didn't bring the court a copy of that Henry Gwinnett County
Oh
grand jury case, but that's
goodness.
the case that counsel relied upon and cited in its.
Folks, you got to get this. I just want to make sure you understand this, okay? This is Attorney Nathan Wade, the government's attorney, who's been paid up to $724,000, up to $1 million for this case. As of right now, he's before the judge, stuttering his words, not able to put his thoughts together evenly. He's pausing, long pauses between words. He's reading what looks to me like from a law book, just basically random bullet points pertaining to grand juries when it should be about special grand juries. He turns to the other attorneys. There's supposed to be a total of 8 of them working for the government, and he can't find his paperwork. I apologize, Judge. I can't find my paperwork. Are you kidding me? What in the world is going on? This should have been what's called a clue. Yes.
In its brief and even in its argument today. But that case is found at 284 Georgia 510, and it stands for the proposition that the requirement that secrecy be maintained among all types. It says all types of grand juries without distinction. So again, the state would submit to the court that there's no difference.
All right. So obviously I'll take a closer look at all the cases you've given me. And I think just as an initial reaction, you're probably right when it goes to saying everything should be turned over. But I want to drill down a little bit more on the witnesses who maybe at this point already, you know that you're going to call in November, right?
Folks, this is a judge that's trying to be as diplomatic, as kind, as gentle as he could be. I've really never seen a judge bend over backwards like this, but of course he knows this is being nationally televised and is going to be reviewed by everybody. He's trying to find a way to say, look, you're wrong, but I'm going to try to help you out here and find a nice, polite way of not embarrassing you in front of everybody.
I think that's the whole point of our scheduling order here. And what we try to do is that we need to use our trial days efficiently and use our jurors' time efficiently. And I would imagine that the state is going to have an order of proof going into this trial with a list of witnesses. And if there are witnesses that are on there, the idea of waiting until the minute before they're called, and then we've got to now pause the trial for an hour or two while then they're reading the transcript, I don't think we can do that. Would you agree?
I agree, and I understand that, Judge. The state wasn't intended to convey that it would hold on to a particular witness's transcript until the eve of trial.
That is not what he said. Now he's going back on what he just said. He just spent 10 minutes telling the court that we don't have to give them anything because anything to do with the grand jury is privileged. It does not have to be released according to the U.S. Supreme Court. I'm on solid ground. This is what Nathan Wade is telling the court, which is not true. And then after the judge gives him a light scolding, he's, well, we had no intention of waiting to the day before trial to produce witnesses. I mean, come on, folks. Does that even pass the laugh test? Do you think you could actually face trial for a crime that can put you in jail for a mandatory 20 years upon conviction? The judge has no discretion to lower that amount. It's hard time, 20 years. Do you think that you can literally have a witness show up and you have no idea what they're going to tell the court? It doesn't even pass the laugh test. And instead of grand juries, he should be talking about special grand juries. Now, listen, I am not going to allow the video to get too long, so we're going to have to start winding it down right now. But join me for the next video here because, folks, we are going to get a little bit deeper into this hearing because what's coming up next is the defense attorneys are going to start ripping and they're going to tell it just like it is. And you're going to see Nathan Wade even more incompetent, if that's even possible. He just looks like a complete idiot, and the defense attorneys please let him know the same. It is really unbelievable that he's been able to get away with this. This should have been a glowing red beacon saying, hey, something's wrong with this case. It is clear to me, ladies and gentlemen, that obviously DA Fani Wade has entered this relationship with Nathan Wade in order to enrich themselves, to make a bunch of money for themselves, to go on vacations to the Napa Valley, take cruises, and at the same time make a name for themselves by taking out Donald Trump and denying you and me the right to vote for who we want as the next president of the United States. This is shameful. I am going to continue to expose this injustice. I had someone in one of the comments tell me something to the effect of, I'm obsessed. Yes, I'm obsessed. I am not going to allow our country to become a banana republic. I am not going to allow us to become a communist society if I can do anything about it. And as long as I still have free speech and YouTube is gracious enough to allow me to talk on their platform, that is exactly what I'm going to do. I'm going to tell you the truth as I see it. If you have a friend, a family member, a neighbor that is suffering from the disease of indoctrination, please share this video with them. Just down below, if you don't know how to do it, click that share button, send it to your friend. Let them listen to what I have to say. Let them make up their own mind. I don't really care if you agree or disagree with me. I just want you to have the information so you can make an informed decision for yourself. Frankly, ladies and gentlemen, I am a firm believer that when you understand better, you can have a better life as a result. It's really just that simple. So be sure to tune in for the next video. If you're still with me, you might as well hit the thumbs up button. Be sure to subscribe so you know when my next videos come out. Always my pleasure to sit down and have a conversation with each and every one of you. I love you. Thank you so much for joining me today. As I always say, always keep that mind free and never give up. Until next time, I am J.R. Dukes.